that, we're going to start.
Still good morning. It is, I'm not entirely sure what time it is in Bogota time. It is 11:17 Bogota time. My name is Jose Antonio Rivas. I am one of the two co-founders of World Arbitration Update. Ian Laird from Kroll and Mooring is the other co-founder. Together with him, we co-founded World Arbitration Update 4 years ago. And in addition to that, just brief introduction of who I am. I teach investment treaty arbitration, public international law, and ICJ judgments at Georgetown Law. I'm also a partner of a boutique law firm based in Washington, D.C., and also with presence in Bogota, Colombia. And what we do there is investment treaty arbitration, international commercial arbitration, and public international law. As to World Arbitration Update, it is with great pleasure that we're doing a World Arbitration Update in Bogota, Colombia. It is part of our Americas program. World Arbitration Update happens, as of this year, 100% in-person events. I say 100% in-person events. This year, we're having no panel that is solely virtual. So every panel that we have this year has happened in the city where we're announcing it. So the first 2 days were in Beijing last week. Then we had a panel in Washington, D.C., where we were. We also had panel in Delhi. We had panel in Warsaw yesterday. In Singapore, we also had panel in Doha, and all of them were in person. It has been 4 years. It seems to be a long time, but if you have 1 day event or one event per year, you only have 4 opportunities to make progress. And this year has been thanks to the team of World Arbitration Update, including Maria Lucia and Maria Camila and many others. We've made huge progress. I would like to introduce Carlos Arevalo. We're doing this panel on a topic that to some may be very foreign for the human rights individuals and international humanitarian law individuals who may be somehow foreign, and likewise for those that do investment treaty arbitration or investment arbitration, talking about international humanitarian law might be foreign. And what we're trying to do in this panel is connect the two of them. Why? Well, Colombia has a long history of internal strife and conflict, and we thought that perhaps it could be relevant. And I'm saying this in a rhetoric manner. Of course it is relevant. Carlos Arevalo has been an incredible supporter of World Arbitration Update. He is not only is he dean of the law school of the Universidad de La Sabana, but he's a thinker. He's incredibly engaged on issues of public international law. Has brought the team or the teams of the Universidad de La Sabana on moot court competitions at the forefront of every competition on moot court and many other things. Whenever I hear about the law school and the Universidad de La Sabana, I'm always hearing good things, and I'm always hearing that connection with international law. So one thing is congratulations, Carlos. World Arbitration Update is very eager to continue working with you, with the Universidad de La Sabana, and thank you for having me on your panel.
No, Jose Antonio, thank you to you for the invitation once again to be part of the World Arbitration Update. definitely a forum that we're really eager to keep supporting, but make sure that keeps growing and growing. Last time I had the honor to be here, we only had one panel. And today we had a full day, four panels, sorry. It's amazing. So thank you for that effort that you're doing with the strategy and with Maria Lucia and with all the people that are helping you to promote this magnificent event. And I know that you are not only a graduate, but very close to Universidad de los Andes. But as I make it public, a commitment, I hope that you soon come and teach for us. It will be fantastic to have you at La Sabana and our programs. So let me start with this panel, which is a very interesting panel because it's a panel of two subjects that apparently do not connect together. It's the unthinkable relationship, investment arbitration and international humanitarian law. But at the end, and especially in today's world, it is a really highly connected topic. And it's a topic that those of you who are experts in investment should realize that there are some norms and discussions in international humanitarian law, as much as those of you who are experts in international humanitarian law should know that the rules of international humanitarian law and the rules of armed conflict could be affected or related with investment arbitration, especially not only with foreign direct investment, but also with the resolution of the conflicts that arise among them. Now, when you think about these two topics, it's unavoidable to talk about fragmentation of international law. And Hafner highlighted in 2000 something that is still being very true today, and it's the fact that there exists no homogeneous system of international law. Existing international law does not consist of one homogeneous legal order, but mostly of different partial systems, producing an unorganized system. The fragmentation of international law is a normative and complex reality that has been marked by the emergence of specialized and apparently autonomous regimes. A reality that might be discussed, as we will do during this panel, to be negative or positive, as was said by the 2006 ILC, International Law Commission report on the subject. On the one hand, fragmentation does create the danger of conflicting and incompatible rules, principles, rule systems, and institutional practice. On the other hand, it reflects the expansion of international legal activity into new fields and the attendant diversification of its objects and also its techniques. Thomas Frank, this emblematic NYU professor, used to say that fragmentation of international law, the speciality of international law, reflects the maturity of the international law system. Now, in an increasingly interconnected world, the possibility of such normative conflicts becomes more likely day to day. Harmonization is the key concept, or principle, if you will, that may solve this discussion and avoid the risks created by fragmentation. One of the reasons why states have become more linked together is the growing number of international investment agreements. Our previous panel surely highlighted that, of which there are 2,222 in force today, according to the United Nations Conference on Trade and Development, UNCTAD. These international investment agreements showcase a particular trend. Close to 70% of worldwide foreign direct investment is directed toward developing economies located in Africa, Asia, and Latin America and the Caribbean, as stated by the 2023 World Investment Report made by the UN Conference on Trade and Development. When relations arise, so do conflicts. It is natural. And in that sense, the number of investor-state dispute settlements have also increased, particularly directed towards the countries of the above-mentioned regions. For example, the most recent exit caseload statistics show up that 46% of the cases filed last year were brought against countries from one of these regions. Now, related to the other regime, we will be based our discussion on today, IHL, International Humanitarian Law. There is also a proliferation of armed conflicts in the world. According to the Geneva Academy of International Law's today's Armed Conflicts report, there are at least 110 armed conflicts between international armed conflicts and non-international armed conflicts. And in this regard, it is noteworthy that at least 80 of those armed conflicts are taking place in Africa and Asia. And Latin America is not a stranger to this reality. For example, just over a month ago, the International Committee of the Red Cross issue its 2024 Humanitarian report about Colombia, pointing out that there are currently 8 non-international armed conflicts taking place in our country, most of them not between the government and the armed groups, but rather between the armed groups themselves. The prevalence of armed conflict exposes the state to increased risks of violations to the rights and legitimate interests of investors, and in that sense, the risk of having international arbitration processes initiated against them. This factor can influence decision-making during periods of widespread violence, where governments already face limitations due to weakened government capacity, infrastructure, and economic instability. Cases that probably are going to come up today, such as APL v. Sri Lanka, Strasbourg v. Libya, Ampal v. Egypt, all of these involving armed conflict, illustrate this situation that I'm talking about. As Tobias Ackerman highlighted in the introduction of his 2022 book, a very interesting book, the sharp rise in arbitration claims lodged in the context of the upheaval in the Arab world and the conflict between Russia and Ukraine are clear indicators of a growing trend of investment disputes in the context of armed conflicts. Case in point, according to the ICSID case statistics, the number of newly filed cases from the Arab world rose sharply in the period from 2011 to 2018. That is, after the Arab Spring, from an average of 6 per year up to 9 per year cases. More recently, publicly known arbitrations arising from the Russia Federation annexation of Crimea from 2014 up to last year have averaged a number of near 5 procedures per year, as stated by the Freshfields law firm. In this complex panorama, the questions arise regarding the relationship between the norms of international humanitarian law and international investment law in context of international or non-international armed conflicts. Now, the problem is not that investment and international humanitarian law issues arise. Rather, that arbitrators are not, this is part of the discussion that we're going to have today, are not addressing them by having recourse to international humanitarian law. A possible cause for it was underlined by Sornaraja. Arbitral tribunals are not designed to deal with political issues such as that's part of the discussion, are they really political issues? Don't worry, we're going to have experts talking about each of the sides. Political issues such as the characterizations of the war, the legality of the force used to suppress it, and other like matters that may concern the internal sovereignty of states. For investment in conflict zones could potentially pressure countries, military, to prioritize specific operations or rescue allocations in certain areas. Additionally, the threat of lawsuits can influence resource allocation during emergencies and post-conflict processes. This can impose undue economic burdens, hindering efforts to establish stability and effective governance. So this is the topic, this is the discussion, and this is why we need to know about investment and international humanitarian law. To address this relation, we're going to have an incredible panel that will address several issues that are related, the interrelation of these two topics. Initially, there will be an intervention by each of the panelists on a specific aspect of this broad topic. Then there will be a follow-up question and commentaries by the panelists to each other's intervention. And finally, we will round things up with Q&A if the times allow it. We are a little bit moved from our schedule, so I'm going to try to go fast. And I know that all my panelists are really, really rigorous with the time use, so we're going to be able to probably catch up with the schedule, because we have 2 more panels ahead. To start, we're going to have Mr. Cesar Coronel, partner in Coronel and Perez, he is an Ecuadorian practitioner with more than 15 years of experience in commercial and investment arbitration in the United States, the United Kingdom, and Ecuador. He will be talking about the historical backgrounds of the development of the investor-state dispute settlement system that exists nowadays. Cesar, the floor is yours.
Thank you, Carlos. Can you hear me okay? Yeah, everyone? Well, let me begin by thanking Carlos and the organizers for inviting me to this conference. It's always a pleasure to be in Colombia. And you know, it's great to have another opportunity to come and, of course, speak about this very interesting topic. I'm coming at this topic from the perspective of, as Carlos said, a practitioner who in the investment arbitration arena. And so when Carlos first told me to come speak about this, I said, well, you know, I really haven't thought that much about international humanitarian law for a while. And it's not entirely obvious to me what I'll have to say, but then, of course, you know, it just took a few minutes and starting reviewing the history of international investment arbitration to realize that the topics really, I mean, have always been there since the very beginning. And what I'll do is I'll talk about the history and the origins of investor-state arbitration, and then at the end sort of try to tie it in with, you know, how does investor-state arbitration deal with situations of armed conflict, and what role international humanitarian law has to play in that. And what's interesting is the very first investor-state arbitration, which is the AAPL versus Sri Lanka case, which Carlos mentioned, had to do with a situation of armed conflict. It concerned the operation of Sri Lankan security forces in an internal conflict, which ended up affecting an investment and not only affecting the shrimp farm of one of the investors, but also leading to the death of several of the employees. And that's, investor arbitration is a relatively new thing, right? So this is a case from the 1990s. But even before that, in the cases that are the precursors of the modern investor-state arbitration cases, you know, the cases heard by mixed claim commissions, they very frequently had to deal with situations of armed conflict, either international or internal. So that's not to say, of course, that there's not new questions that are arising all the time. But I'll try to illustrate this a little bit. So first, let me talk very briefly, and you all have heard, you know, this before, but I think it's important to remind ourselves of, you know, how we ended up in the world of modern investor-state arbitrations. So substantive provisions, substantive protections for foreign investors have really always existed in modern international law, right? In customary international law, and then in the friendship, commerce, and navigation treaties that were very common in the 19th century. But the way in which these protections were sort of made it to adjudication has changed significantly. And then also, of course, there's been an evolution in the way in which these substantive protections have been incorporated in international law. So first, you know, at the beginning we were in the world of diplomatic espousal, where the protections that were either in customary international law or in treaties were, of course, there to protect foreign investors, but if there was a claim, then it was the state who had to espouse the claim, and it became a dispute or negotiation between the two countries, the country of the investor and the host state, and that's how espousal worked. This, of course, raised several issues and had several difficulties, including the fact that the investor had to convince its state to espouse the claim, right? And that every sort of investment dispute had, you know, it was very easy for it to become an interstate conflict. States try to deal with this in several ways, and one of the ways in which this happened was by the creation of mixed claim commissions, and sort of to try to remove this from the purely diplomatic process and have it become more of a case of adjudication. Investors then, I'm going to go very fast in this section, but investors then, you know, started bringing claims directly against states on the basis of what they called internationalized contracts, contracts that were arguably governed by international law and not the domestic law of the state. So then we started seeing mechanisms whereby investors were directly filing claims against states governed by international law. And then eventually, these protections that were in friendship, commerce, and navigation treaties and in customary international law made it to the modern bilateral investment protection treaties that not only incorporated these protections, but also created an avenue for adjudication called investor-state arbitration, which is basically the ability for an investor from one country to bring a claim in arbitration against the host state. Now, these treaties have evolved, right? I mentioned the Friendship, Commerce, and Navigation treaties. We didn't include arbitration provisions, but included substantive provisions that very much resemble the ones that we have in the modern BITs. Then we had the creation of the BIT Convention, which created sort of a particular forum for the adjudication and eventual execution of the awards rendered in these sorts of arbitrations. Of course, the ICSID system includes both contract-based arbitration and treaty-based arbitration. And then, of course, we ended up with the modern treaties, of which there was some discussion earlier today, that are mostly bilateral. I mean, there are some multilateral instruments that incorporate these protections, but most of them are bilateral. And so it's very fragmented, but at the same time, many of these treaties include very similar protections and follow a common structure. Now, if we can go to the third slide, because I already went through whatever was on the second one. Yeah, let's go to the third, the one after that. So now this is where it gets interesting and where sort of armed conflict comes into play. We all know generally what the BITs say, right? They protect certain investments, they protect certain investors, they set forth certain guarantees like fair and equitable treatment and full protection and security, which mean basically that the investor cannot be discriminated against, that there is a minimal level of physical security that has to be provided by the state, etc. There's a protection usually against expropriation. There's what we call the umbrella clauses that basically enable contract-related claims to become treaty-related claims. And then these treaties establish usually at least some defenses that the state can bring forth to defend itself against claims brought by investors. Now, in all of these areas, we have seen in the cases that we've seen in the past, and I think we will continue to see the relevance of or the importance of arbitrators being attuned to the impact of an armed conflict, and then, of course, the relevance of international humanitarian law. So, for example, in some of the recent cases related to the Russian occupation of Crimea, arbitrators have had to deal with the question of, well, I mean, so this is Ukrainian territory, but some investors are bringing claims against Russia for activities in Crimea. And so the arbitrators had to decide whether they were applying this BIT to activities in Crimea as if it were Russia. We've had, for example, modified interpretations or the necessity to interpret fair and equitable treatment and full protection and security clauses in light of very unusual situations where the protection that the state can provide is just not the same as the protection that it could provide under circumstances where there isn't an armed conflict, internal or international. We've had more detailed discussions about the justifications and excuses available to states. I mean, the question arises, can a state invoke different defenses and justifications for its actions when it's in a situation of armed conflict that it cannot otherwise invoke? And so, and I'll be wrapping up soon, I promise. And so, like I said, from the beginning, ever since we've had investor-state arbitrations, again, since the very first investor-state arbitration, arbitrators have had to deal with that. And in the cases previous to that, they had to deal with insurgencies, situations where the abilities of the states to protect investors were limited. But these situations are just happening more and more these days. And of course, we have more development of international humanitarian law. And then the treaties, the modern BITs, have incorporated, many of these treaties have incorporated clauses specifically referencing situations of armed conflict and using terms that are terms of art in international humanitarian law. So we have clauses that speak about requisitioning of investments, or clauses that talk about the specific rights of investors where there is a situation of armed conflict, and give investors the certain rights to claim compensation in these situations. And I think that's where international humanitarian law comes in more directly. It's, and I think, and we'll talk more about it in the minutes devoted to discussion, but definitely the developments in international humanitarian law and the development of these concepts are definitely relevant when adjudicating these cases. So I'll leave it at that, and then I have many more things to say, but I'll say them when we are in discussion.
Maybe later. Thank you. Thank you for being, and I'm sorry to be the one that has to stop this very interesting, but we want to, get into schedule. Now, let's move to our second panelist, and then maybe if we have time left later at the end, we can ask some questions on your presentation, Cesar. Thank you very much. We have something that I want to say is that in this panel, we're really very good friends, all of us. We know for many years, Cesar and I, we studied together at NYU, so it's always great to be among friends. And I hope that you guys see it, how much we enjoy the preparation of the panel and how much we're going to enjoy our discussions. Now let's go to Professor Freya Buttons. She's a professor of public international law and the director of the International Human Rights Law Summer School and research director of the Oxford University Human Rights Hub. She will be answering the question of whether there exists a conflict of norms between international humanitarian law and investment law, and how these normative tensions might be resolved. Freya, I know that you're not only a great international human rights academic and in every field related to protection of persons, but also you are a great advocate for non-fragmentation and for the harmonization of regimes. So the floor is all yours to answer this question, Professor Buttons.
Thank you very much. And it's a great pleasure. I can't be there. I would have loved to come over, but unfortunately it wasn't possible. I was sharing my slides, but I now get a message saying stopped sharing Microsoft PowerPoint, so that's not good. Shall I just say resume?
Freya?
No?
Yeah, hello.
Yes?
Could you again try to share your slides? Thank you.
Okay, stop. Share. Does that work at all?
We're only seeing white.
Just give us just a few.
No, it's not white. I can promise you that.
No, we saw the
okay,
title,
I'll try
so we
one
know
last
it's not.
time.
No,
We know it's not. We know it's not.
It's been fixed. So just to all that are in person and online, just a few seconds, so that all the work that Freya has put into it will show as well.
Yes, we're like not. It's not a huge. It's only one slide, but it worked a second ago. Okay, I'll try one last time, and otherwise I can do it without a slide as well. I have a text in front of me, so.
Don't worry, we have your presentation and we will try to do it
so
ourselves.
So what we will do is we will share your slide, and perhaps we can share it for a few minutes, and then we'll show you again.
There you go. We have your presentation now.
But now we don't have you. But yeah, we can hear you.
Now? Oh.
No, we don't have you, but we'll switch into you in a few minutes.
Sure, no problem.
Okay, well, there we go. even after so many years of doing things online, it's possible to still get it wrong. I'm very sorry for that. I was asked to answer a question whether there is a normative conflict between international investment law and international humanitarian law. And I want to focus in particular on the elements of precaution or due diligence and proportionality. And what that means is that a problem may arise if a certain conduct is mandated or permitted under international humanitarian law while also constituting a breach of the investment treaty. So that is traditionally fragmentation. It's a topic that has been with great enthusiasm addressed by various academics. And many of them, and I'm now referring to the work of Hernandez, Mayorga, Burke-White, many of them say, well, the investment regime is insufficient or is inadequately engaged with other coexisting legal regimes. I hear, is somebody trying to tell me something?
Oh, sorry.
No problem, no problem. I was just going to say, I understand Spanish, but if you whisper, I can't.
Later you can tell us how it sounds. Like,
Think up loudly. So what many scholars have argued is IHL is more suitable and should displace essentially investment law protection. Now, what I would say, and I don't only say that as an academic, I say that as somebody who has been involved in quite a number of investment arbitration cases, either as expert or counsel or working for the institution that was administering the conflict. I would say I do not see the problem at all. There is no particular reason why you could not interpret international humanitarian law and international investment law in a way that you respect the obligations under both. In many cases, the two regimes will, for example, not overlap at all. They address different issues. International humanitarian law will deal with the protection of wounded soldiers, for example, which is not something that will be relevant for investment law. And often they are complementary. So international humanitarian law will prohibit pillaging. That will also be prohibited under international investment law under the full protection security standard. So these two regimes can support each other without much diversion. Strictly speaking, a normative conflict is, sort of the definition is that if a party to two treaties cannot simultaneously comply with obligations under both treaties, so they're mutually exclusive. But actually, no one's ever been able, with regard to investment law and humanitarian law, to identify such clearly conflicting obligations. Others say, well, it's not just about mutually exclusive, but also that one field would be much more or much less demanding than the other. And you can see that, for example, in the ILC fragmentation report. But even in that case, what I would like to argue is that conflict can still be avoided through interpretive tools. So just to give you an example, on the one hand, you have people who argue that the investment treaty's FPS standard and the IHL principle of military necessity are conflicting. Why? Because humanitarian law does allow a belligerent state to attack a lawful target. However, states are allowed to rely on their police powers, which is a common concept in investment law, and they are allowed to do so to protect their essential interests. They also have to reasonably exercise belligerent rights under international humanitarian law. So that's one way to see where these two fields touch but do not conflict. Another example is the sequestration of enemy investment property. That is possible, and some would say, well, that is prohibited under investment law because it's indirect expropriation and that needs to be compensated. But on the other hand, again, as an exercise of police powers, it is allowed under investment law and even under international humanitarian law. The idea of sequestration is that you temporarily seize assets for security reasons, and then either you return them or you pay compensation. So again, not so different. One example where I would like to discuss in a bit more in detail is the the rule on precaution in military operations and whether there could be any stricter due diligence standard under the full protection and security provision. Now, you have already heard a good analysis of the APL versus Sri Lanka case, so I will not detail, say in detail what this case was about. But essentially, the idea was that the investors said they had cooperated with the state, and in spite of that, their investment, their farm was damaged, whereas the government said, well, no, the farm was cooperating with terrorists. They violently resisted the military operation, and so the destruction of the farm was by the Tamil Tigers, by the rebellious forces, not by the government itself. Now, it was without any question that the area was infiltrated by rebels and not under government control, but it was also established that the farm's management actually did cooperate with the government, and that the government did not make any attempt to remove people, to warn people that an attack was imminent. And that led the tribunal to conclude that security forces had failed to take precautionary measures and failed also to comply with its due diligence obligations. Now, there was a dissent in that case, and the dissent was based on the argument that a host state would not be reliable for losses sustained by foreigners during insurrections, and also that the due diligence standard did not or does not apply when the government loses control. Now, I would argue that in this case, the majority actually got it right, and the dissent is wrong, because IHL does impose a due diligence standard on belligerent parties. We can find that, for example, in the additional Protocol 1 to the Geneva Conventions, where Article 57 does provide a duty to exercise care. It might not be exactly the same term, but it is the same idea. Both in identifying the military objective, but also in calculating the effects of your attack. And a belligerent party, therefore, is obliged to take all feasible precautions in the choice of the means and the methods of attack, particularly when civilians are involved. Even a state's loss of control over its territory does not, either under IHL or under investment law, provide an automatic exemption should it fail to exercise due diligence in the planning of its military operations. The argument that IHL is somehow more permissive in measuring state diligence when talking about precautions is therefore open to serious doubt. In both regimes, the standard of diligence does take into account the state's existing capabilities, and that includes financial and technical resources. But so both standards require that a state exercises caution. Moving now to proportionality. Again, starting from additional Protocol 1, Article 57 stipulates that precaution should include refraining from launching an attack which may be expected to violate the principle of proportionality. So it prohibits an attack that would be excessive in relation to the concrete and direct military advantage. And that is based on a rather elusive standard of a reasonable military commander who must carefully weigh humanitarian and military interests. And again, and this is interesting, and it shows how these two fields go really hand in hand. The investor in APL based its claim against Sri Lanka, among other, upon a breach of the proportionality standard in its military attack on this particular farm. And when you read the award, and particularly if you read an investment award, but you have read, for example, human rights courts judgments or judgments of the International Criminal Court, you see that there is a proportionality analysis that is actually quite similar in these three different fields. So what the tribunal did was it did refer to appropriate deference to the state, but still it acknowledged the legitimacy of the aim of the operation and the suitability of the measure, but it balanced the response of the state, the attack, to the effects on the ground. And then again, the management of the farm was not cooperating with terrorists. There was no evidence that they had been supporting or hiding terrorists. On the contrary, there was actually evidence that they had been cooperating with the security forces. Moving on, what should we do? What are the methods of resolving any potential normative tension? Now, the first one is a political solution. I think states so far have been rather, there have been cases, but they've been rather unlikely to raise IHL-based arguments because they often try to avoid the complications of bringing IHL into an investment debate for political reasons. For example, it's hard for a state to admit that it lost control over a large part of its territory. Another hurdle would be, or another solution would be to look at jurisdictional clauses in investment treaties. And there we actually have two kind of groups of treaties. Some restrict the tribunal's jurisdiction to disputes concerning the investment treaty standards. But many treaties, and I would argue that these are the better drafted treaties, really, they open up the jurisdictional scope so as to cover any dispute relating to the investment. Now, under the first standard, if you really can only talk about investment treaty standards, it becomes very hard to combine IHL and investment law in your analysis as a tribunal. However, under the second standard, when you can look at anything relating to the dispute, any dispute relating to the investment, you can also look at other sources than investment treaties or violations of international norms. A third option is treaty drafting, and not just about the jurisdictional clauses, but treaty drafting about concerning the investment standards. One thing states could do in order to protect themselves, or in order to make clear that, for example, they prefer to rely on IHL rather than investment law, is to provide carve-outs in the way of security exceptions, or more specifically through advanced conflict clauses and express and precise demarcation of substantive standards, police powers clauses, in other words. So by negotiating this, they do not only shift the risk of bearing some conflict-related losses to foreign investors, which arguably is what many states would like to do, but they also reduce the scope of conflict between laws. Now imagine you have a treaty that contains nothing of the sort, and as a tribunal you're faced with a situation where IHL did play a role. One thing you might think about is to look at the lex specialis rule, but then the question is, which is the more special rule, the more specific rule? And again, there I would agree with people like Jure Cvrilic, for example, who says that the content of investment treaty standards is influenced by the law of state responsibility for injuries to foreigners under customary international law. So actually, the origins of both investment law, human rights law, and IHL are to a large extent similar. So there is no real lex specialis. The recourse to IHL in your interpretation of investment law therefore seems a logical consequence. Another option is to look at jus in bello normative elements as factual circumstances that inform your interpretation of the treaty. One element is, for example, the existence of an armed conflict, which might well be enormously influential on what you consider to be obligations under the due diligence standard. Another one might be, what if you have a situation in which an investor does participate in combat, and how the state has to respond to that? Does it take away all the obligations of the state under the investment treaty? No. It also doesn't take all obligations of the state away under the human rights treaty. So the tribunals can take into account that the fact that a targeted person, a targeted investor, participated in hostilities, and then, of course, that will inform the claim or the success of the claim that is brought afterwards. Furthermore, there are a whole series of concepts, rules and principles in international law that might be of help looking at good faith, looking at equity, among other. And again, as I said, the principle of proportionality, perhaps first and foremost, would be guidance in interpreting your investment treaty. And then finally, there is this much beloved academic concept of systemic integration. Those of you who have studied public international law might remember Article 31(3)(c) of the Vienna Convention, the law of treaties, which requires that other applicable rules of international law are to be taken into account when interpreting a treaty. And that allows a tribunal to bring in other obligations of the state in its balancing exercise. And it shows, as already the AAPL tribunal also said, that the BIT is not a self-contained closed legal system. Now, that also entails certain difficulties. Well, first of all, an investor could say, well, these other international obligations are not binding on me, so they would not be directly applied to the investor. But of course, they can inform the interpretation of the investment treaty, but it could arguably create some misinterpretation, some conflicting jurisprudence, and also there is then, you give tribunals a lot of power in a lot of discretion in formulating the applicable norm. Now, in conclusion, the tension between IHL and investment law has invited quite a bit of criticism, as an investment law interpretation has been inviting criticism, and arguably some say this unfairly suppresses the state's sovereign right to defend itself. There's not enough heed to be paid to the norms and principles of IHL. I would, on the other hand, argue that these claims have to be rejected. I think so far, particularly the AAPL judgment, but also others, have been accurate and fair in their outcome and have not contradicted the norms of IHL. It has been argued that the potential for a genuine normative conflict to materialize between the two regimes is unlikely. I have tried to give you some political reasons, jurisdictional reasons, and interpretation and of the substantive treaty standards. So in one final sentence, I would say investment law equips tribunals with sufficient tools to mitigate normative tensions between investment and IHL and to arrive at a balanced conclusion. Thank you very much.
Thank you very much for your presentation. I mean, especially the base that you did on proportionality, precaution, due diligence, and approach from the principles and the proposal of solutions to avoid normative conflicts that are, it seems to be apparent but not real. Thank you for that approach, certainly an approach based on not fragmentation. Now we give the floor to our dear host, Jose Antonio Rivas, a founding partner of a strategy law firm, director of its arbitration and international law practice, and co-founder of the World Arbitration Update and the Washington Arbitration Week. He will reach out to the topic of international humanitarian law in relation to the jurisdiction of investor-state arbitral tribunals. The floor is yours, Jose Antonio.
Thank you. Thank you, Carlos, and thank you, Freya, for that presentation. I would like to address really three issues, and I beg Carlos to push me on time if I don't get there. The first issue is related to is one that I would describe as a jurisdictional issue. The question that was posed to us during our internal preparation was can treaty arbitration tribunals judge over international humanitarian matters, or are they barred from applying or interpreting those norms because of jurisdictional clauses? This is a jurisdictional question. The next question that I will deal with is if they can hear it, how can we apply also international humanitarian law in investment treaty arbitrations? And the third issue that I will try to address is in the context specifically of countries that are living civil strife or internal armed conflict. What could this mean? So I will try to get practical within the bounds of the time allotted. Now, on the first issue, I think that I will not I will not repeat much of what Freya has provided. I fully agree that anybody seeing investor-state arbitration as a silo or as an independent type of legal system is somehow, well, I can only say it this way, is wrong. Investor-state arbitration, international investment arbitration, is part of public international law, and there are sufficient clauses within the main center of arbitration, ICSID Convention, and other instruments that are applicable, specifically bilateral investment treaties and free trade agreements with investment chapters, to emphasize that investment treaty arbitration and that investment arbitration is part of a larger public international law system, and it should not be fragmented. Now, how does that apply, or where are the sources? Well, a few sources. If we go into the ICSID Convention, Article 42, just to leave no doubt about it, it reads in paragraph 1, the tribunal shall decide a dispute in accordance with such rules of law as may be agreed by the parties. And of course, if the submission is under a bilateral investment treaty and the request for arbitration relies on a bilateral investment treaty, the applicable law is the bilateral investment treaty. But even we go further, in the absence of such agreement, the tribunal shall apply the law of the contracting state, party to the dispute, the host state, including its rules on the conflict of laws, and here's a greater emphasis, and such rules of international law as may be applicable. So there's that provision. Investment treaties, some of them do have an express reference to the application of international law, and that further confirms that we are in a system. We're not in a silo when we're talking about investment arbitration. Now, having said that, there are few cases that have made specific reference, and we have talked in the prior panel on the Urbasser case. That's exactly what the tribunal saw when the Argentine Republic submitted a counterclaim alleging the violation of the human right to provision of water, and that's what it says. Well, we are under international law, and that's why we were going to hear the claim or the counterclaim. So this could happen also in cases involving not only international human rights but also international humanitarian law. So in terms of jurisdiction, to me, it's quite obvious that there's that. Now, the next question is the next question that I would like to address is, assuming, for the sake of discussion, that investment tribunals should consider international humanitarian law when addressing investment issues occurred in conflict areas, how must an arbitration tribunal take into account the existence of an armed conflict when assessing the conduct of both the state and the investor? In order to address this question, what I would like to do is walk the audience very quickly through each one of, or not each one, at least a few classic traditional investment treaty standards, namely full protection and security, which is perhaps the most obvious one concerning international humanitarian law, but also address it with respect to fair and equitable treatment and perhaps indirect expropriation. With regard to full protection and security, here the obligation by the state is one of due diligence. The state is not bound to guarantee an obligation of result when there is an issue of security, physical security against the investor or against the investment. There are some things that are impossible to guarantee. Think about the terrorist attack 9/11, Twin Towers, I'm sure that there were foreign investors in those buildings. The state is not liable for that. It's impossible to be liable. What the state is liable for is conduct a due diligence to try to protect those investments and those investors. And if they fail to do so because there are some acts that may not be prevented, then the state is bound to prosecute those that were responsible for those acts. So there's an obligation to prosecute, to open certain judicial proceedings, and see that the investor will get some redress. That's the obligation of full protection and security in a classical customary law understood manner. So how does this play into? Well, this plays into because the state may not be liable if it tries to do what it can and then follow up by prosecuting those responsible that may have affected the investor. So think in a situation of a conflict of internal armed conflict. Think about the explosion of pipelines in the southern part of Colombia by paramilitaries or by guerrillas. So the question is whether the Colombian state would be liable for that. Well, if it did nothing, perhaps, but if it tried to do what it could have done in the existing circumstances, and this is important for full protection and security. Existing circumstances is not the same in Colombia as they may be in Denmark. So full protection and security is a provision that has to be interpreted in accordance to the circumstances where the investment is made. Now, if the state tried to do everything it could in those circumstances, and then still the blowing off of the pipeline occurred, then it should prosecute those that were responsible. As long as it does that, I believe that there could be no liability under full protection and security. If it doesn't do its due diligence, well, the state would be in trouble. So just to put an example. Now, to move further on, fair and equitable treatment, there the obligations, there's many obligations there, and due process, non-denial of justice, not acting in an arbitrary manner, all those should in many respects take into account not only the obligations vis-a-vis the investor, for instance, concerning an environmental permit to be granted, but also the applicable normative that the state has concerning international humanitarian law. So when you're applying any regulation, internal regulation, to follow due process and to follow the law, to treat the investor in a due process type of manner, you also have to be applying the rules that are within the system. And that's mainly local law, but also adopting international human rights, international humanitarian law. So that's another way that you would be applying local law in a due process manner vis-a-vis the investor. Now, expropriation, and I know this. I only have a few minutes, but expropriation. I think that if we're referring to indirect expropriation, unless there is a suspension of the treaty, if we're talking about direct expropriation, you would have to pay compensation ultimately, unless, of course, there's the defense. And there could be, and I'm not yet on the defenses. I'll get into the defenses. Indirect expropriation, however, has some clauses, for instance, in the investment treaty or the FTA between Colombia and Canada, where the annex on indirect expropriation has at the bottom part of the annex a reference to an exception which basically provides that if there are measures taken by the state in a proportionate manner for the sake of certain public purposes, including the environment, health, amongst others, but it's a non-exclusive list, then the measures taken by the state may be understood as non-expropriatory, to the extent that those measures are taken in a proportionate manner and that they're non-discriminatory. So there are tests. So here the issue is big, because if you are able to argue that whatever measure the state took was proportionate and was non-discriminatory, then you may be in front of measures that are not concluded to be expropriatory. So, and that's important, because if you do that, you don't even have to go to an additional exception. Now we're going to the general exceptions. The general exceptions, there may be treaties that allow you to apply a major exception, such as the one that we were discussing, the general exception carve out on issues of human rights or an environment, and query as to that could be extended into international humanitarian law. I don't have the answer, but that's a question to be posed there. Now, we've gone through claims, some exception, and now we go into another category, which is circumstances precluding wrongfulness. Circumstances precluding wrongfulness are not an exception as such. They simply suspend, as long as the circumstance exists, they suspend the application of the treaty, and they may lead to no liability or they may lead to no damages, depending on whether the circumstance exists. And the one circumstance that we have to talk about is necessity. So if there are circumstances by which the state was not the one creating the circumstance, and the state took some measures that are proportionate to protect a key interest of the state, at least for the time that the circumstance exists, for instance, for the time that in this case, for the time that the conflict, internal armed conflict exists, you would be able to suspend liability or even the damages. Finally, Finally, so we've gone through question number 1, question number 2. Now we go into question number 3. Question number 3 is, well, what about specific actors in a state with a non-international conflict, as in Colombia, but also in many other places like the Arab world and other continents? Well, on that, one question that comes to mind is, what if the investors are somehow involved in financing some of the actors of the conflict, and without, of course, I mean, by all means, without trying to justify any of those financing, the investors may be or may feel that they're put in a position where they either pay some financing to the actors that have true power in those specific regional jurisdictions, or they cannot continue doing business. First of all, that's of course unlawful. But second of all, could that lead to some declaration of liability for the investor? And the answer there is well, it should. Unfortunately, it may not have happened to the extent that the treaty may not create direct obligations for the investors. And it could be as a matter of domestic law, but as far as I understand tribunals, and I've seen tribunals have been timid in requiring investors to comply with human rights obligations. So on that, there's a big scope to create greater reform of treaties, not only including obligations related to human rights, but even obligations respectful of minimum standards of international humanitarian law. So ultimately, it would be an investor should also be liable if they, at any time, finance any unlawful actors that eventually breached international humanitarian law or international human rights. We could go further and further, but I know that my time is up. Thank you.
Thank you, thank you. And I'm sorry, don't blame me. You created the format. So no, thank you. Thank you very much, especially because I think your approach, because there are not many people, I mean, probably 5 scholars talking about these topics that have written substantially about it, not many more. And usually the examples they use are international armed conflict examples. And I think what is fantastic about your presentation is that you gave a non-international armed conflict approach, which for regions like Colombia, we can discuss maybe Ecuador and Mexico, Brazil, etc., are very interesting. So thank you very much for that approach. Now, continuing with the discussion and concepts like due diligence and fair and equitable treatment has been constantly approached by all our panelists. And in that sense, I think it's fair to introduce Professor Sebastián Mantilla, who's a professor of international economic law in Fletcher School of Law and Diplomacy of the Tufts University in Boston. Probably, and it's not only because I'm his friend, but honestly, the person that best known and has been approached full protection and security in the world. And if you don't believe me, buy his book on full protection and security in international law by Springer and read it. And then you will realize that probably is the most deep and well done and rigorous approach to the subject. So he will specifically talk about the relevance of international humanitarian law in assessing compliance with the full and protection and security standard in the context of armed conflicts. Sebastián, thank you. He's Colombian, so it's great to have you, although you're a brain that has gone to Boston now. But thank you for being here with us. Hopefully next time we'll have you here present.
Thank you, Carlos, for that very kind introduction. And I think the organizers will be sharing my presentation in a moment. So my name is Jose Mantilla. I am an assistant professor of international economic law at the Fletcher School of Law and Diplomacy. And today I will be speaking about this intersection between full protection and security and the law of armed conflict.
Yes, Pastor.
Sebastián, I'm sorry, can you speak a little bit louder? Because it might be the room, but we're not hearing you very well. If you could speak a little bit louder, that'll help. Thank you.
So are you, is sound better now?
Yes, it's
A bit better.
Yeah. So I mean, Carlos, with your permission, just to interject, Sebastián, if you speak louder and closer to the microphone and slower, that would be great, because everything is being taped, and our AI tool will recognize every word better if we go slow. Thank you.
Okay. I hope that the microphone is working now. So, as stated by Carlos, and thank you for that kind introduction. I am presenting today a very short introduction to this intersection between full protection and security and the law of armed conflict. Please, next slide. To begin my presentation, I think it is useful to start with examples. And full protection and security has been at the heart of some recent cases about the protection of investments in context of armed conflict. A famous case was Strabag versus Libya, where a company that had invested in several construction projects suffered substantial losses in the course of the Libyan civil war and filed for arbitration alleging a violation by Libya of Article 3, Paragraph 1 of the Libya-Austria BIT. This treaty provides a fairly common full protection and security clause. If you look at it, it guarantees investors fair and equitable treatment, and full and constant protection and security. Full protection and security clauses are fairly diverse. Some use the adjective full, others use the adjective constant. Very few clauses use the adjective legal, but they are fairly similar. Next slide, please. The full protection and security standard is an obligation, or entails an obligation, to exercise due diligence in the protection of the investment. There has been some debate and some inconsistent decisions regarding the question whether full protection and security provides only physical protection, whether it extends to legal security. And there are several cases like El Paso versus Argentina that limit the scope of the standard to the protection of the investment against third parties. There is some coherent approach among tribunals in saying that full protection and security is an obligation of due diligence. And I think today's presentation should focus precisely on the concept of due diligence and how that concept might provide an avenue to consider issues of international humanitarian law when assessing full protection and security claims. And to address due diligence, we have to acknowledge that it is a very broad standard with a scope and a meaning that is hard to determine at the outset. In my view, there is a clue, or there are several clues as to the meaning of due diligence, which we can derive from the fact that full protection and security is generally regarded as part of a broader standard that is called the minimum standard of treatment. In my presentation, you will find Article 14 of the United States-Mexico-Canada Agreement, which is the agreement that replaced NAFTA. And in this agreement, you see that full protection and security appears as an element of this customary minimum standard. Now, the minimum standard can be understood from a historical perspective as the opposite to the doctrine of equality. It means that foreigners are entitled to a minimum degree of treatment that can, in certain circumstances, go even beyond the treatment that a state grants to its own citizens. It is an objective minimum that is independent of the way how the state treats its own citizens. This tells us several things. The first one is that the minimum standard and due diligence cannot be defined by the way how the state treats its own investors. So failure to protect domestic investors does not justify a failure to protect foreign investors. Second, the minimum standard is a bottom line, it's an absolute minimum. And this means that due diligence is also a very low standard. So a breach of due diligence requires tribunals to think about the threshold of an average rather than an ideal state. It is a minimum. Next slide, please. And this brings me in this very short presentation, which we can discuss later in a different setting, to the potential relevance of considerations of international humanitarian law for the assessment of full protection and security claims. The first element we can consider in this context is the so-called notion of a modified objective standard of due diligence. This language might sound somehow somewhat technical. It is a language that has been used by several tribunals in the past to convey the idea that the assessment of due diligence has to consider the specific circumstances of the host state. This notion of a modified objective standard is a notion with which I agree, but I disagree on the label. So I have shown in some publications in the past that the understanding of due diligence from a historical perspective has always been an understanding that takes into consideration the specific circumstances of the state. In my presentation, you find a reference to a diplomatic note by US Secretary of State Thomas Bayard in the 19th century, which I am happy to share after the presentation. And if you compare that note with modern investment treaty cases, you will see that Bayard comes very close to this idea of a modified objective standard. The implication for the relevance of international humanitarian law in the context of full protection and security claims is that tribunals are in need to recognize the specific circumstances of the state that fails to protect the investor. And those circumstances certainly include the fact that the state is facing an armed conflict. So that circumstance has to flow into the analysis of the FPS claim. Moving on to the second element, due diligence is part of an obligation, which is in turn an element of the international minimum standard. Since the minimum standard is an absolute bottom line, it is the absolute minimum you can require of the state. Other international obligations, in principle, will set higher standards, so that if the state is able to show that it complied in similar circumstances or in the same factual setting with higher obligations of diligence, that is also an indication that it complied with the lower standard set by the minimum standard. These considerations have already appeared in some cases, not in the context of armed conflict, but in relation to environmental obligations. Those interested in this notion can check the case Peter Allard versus Barbados of 2016. Now let's move to the third element. The notion of due diligence is very flexible, and it is a very complex notion. The idea behind due diligence is hard to define in general terms because we are in front of a standard that is capable of being adapted to the specific circumstances that a tribunal is considering. Due diligence allows to consider the rationale behind the conduct of the state. And this rationale has to consider that the state in a situation of armed conflict needs to protect not only the investor, but also other stakeholders. And it also has to comply with applicable standards under other subfields of public international law, so that this rationale of the state conduct can serve as a means to justify its conduct from the perspective of due diligence. You can show that the state has not been arbitrary in its failure to protect the investment. I am just over 7 minutes, so I will conclude my presentation with these thoughts, and I look forward to discussing them in more detail after the last presentation. Thank you for your attention.
Thank you. Thank you very much, Sebastian. I mean, it's really interesting to have this concept of minimum standard, modified objective standard, and then the flexibility in due diligence, because I think we have, correct me, Marcela, if I'm wrong, but I think it was Marco Sassoli in the IHL world who also created how, when we apply standards to to groups, I mean armed groups in non-international conflicts, those rules has also be applying a sliding slate, idea of it depends on the context and how you're going to apply those rules depending on that context. So to see that from the fair and equitable treatments, when it comes to due diligence, we also have that discussion on how the rationale of the state conduct and the context could be taken into account is really interesting and might be a point of connection between the two subjects. So thank you for your presentation. And last but certainly not least, our good friend Justice Marcela Giraldo, who is a judge in the Special Jurisdiction for Peace. And thank you really, Marcela, for accepting the invitation to talk about this topic with us, because I know that by accepting the invitation, there are many things that you had to do that you're not doing. And I know we are already over time. So thank you very much. Probably, and again, not because I'm his friend, but because I truly know, and being myself an expert in international humanitarian law, I'm not afraid to say that she's probably the person that today better knows this topic and its relationship with transitional justice. So Marcela has also been a practitioner before in the Inter-American Court of Human Rights, and she had quite experience in the International Committee of the Red Cross and the International Criminal Court. She will be addressing a particularly interesting topic related to the context of Colombia, and that is the relationship between transitional justice processes and international arbitration tribunals. Thank you very much, Marcela.
Thank you. I don't know if you were right about that, but I will do my best to share with you my knowledge on IHL. I know nothing about investment law, but I think I gathered some ideas that could be interesting for you. The first thing that I would like to say is that you need to classify the situation. Because one of the things that I have heard, for example, you were talking about terrorist attacks. Sometimes terrorist attacks occur outside the scope of non-international armed conflict, and then you will only have IHL as a norm for armed conflicts. Otherwise, you will be with local law or international human rights law, or even maybe crimes against humanity with the international criminal law, but you will not have IHL as an applicable law. So you have two types of conflicts. Some are international armed conflicts between states, and non-international armed conflicts between state and a non-state actor, or between them. As Carlos was saying, we have here 8 armed conflicts in Colombia. So you need to know which are the parties to the conflict in order to know if there is a conflict that you can bring IHL to analyze the situation. Also, depending on the type of conflict, you will have more IHL rules applicable. For example, for international armed conflicts, we have around 600 articles in the Geneva Conventions, where for non-international armed conflicts, we have only 29, and customary international humanitarian law. So the applicable law will vary between the two, and it will have an impact on the rules that you can bring for analyzing the situation for example, in a tribunal, arbitration tribunal, as the ones that you are studying in investment law. Okay, so can we? Yes. So I'd like to talk to you about this with the transitional justice, because we were talking about, well, if there is a transitional justice mechanism in a place, for example, as Colombia, that we have some, the special jurisdiction is a transitional justice mechanism, but we also have non-international armed conflicts going on. So we have like peace initiatives, but also armed conflicts. So I think there are it's very challenging for you, for the treaties that you are working on, to see which clauses add and which legal framework will be applicable. But I think one of the things that could be interesting will be to broadening the applicable sources of law, so integrating IHL and international human rights law to interpreting international investors' obligations. I think you were talking about that is like growing the idea of looking at these frameworks of law for interpreting the investors' obligations and also the state's obligations. So I hope it continues growing, because that will give more protection to civilians in cases of armed conflict. In the special jurisdiction for peace, I would like to talk about 2 cases of precautionary measures that have been studied by us. One thing is that in Colombia, we don't have legislation, for example, for searching, that requires the searching of missing people when, for example, a big project is going to be built. We only have some legislation for archaeological findings. So we have these 2 cases, Hidroituango Dam and the Dique Canal, where they are going to build some locks for the canal. And in the first one, we have like the flooding of the area happened before it was able to pursue some to pursue some looking for the disappearing peoples that allegedly are in the area. So there were no searching plans on place before the flooding of the area. So now we have many challenges because there are many people saying that they were enforced disappearance cases here, and we are unable now to find the bodies or the remains, the human remains of the people that it's supposed to be there. So for the Canal del Dique, it's a different situation because before the project is built, with the jurisdiction and the General Attorney's Office from Colombia and the search unit for the missing person that is also created in the same peace agreement as the jurisdiction, and also with the international investors in this canal and the community, they all gathered together and created a protocol for the search of the missing people, and is within the contract obligations of the international investor. So this is like a new thing because that didn't, for example, happen in the Hidroituango, and now the investor is not only agreeing to have this protocol for the search, but also this brings together the local authorities, the transitional justice mechanisms, and also the community. And the idea is that the investor is going to give information to the General Attorney's Office and the Search for Unit Missing People about the area where the project is going to be taking place so that they can pursue searching protocols or searching efforts for the missing people before the logs are built. And also the investor is going to hire a forensic team in case when building the logs, they find some human remains so that the forensic team from the investor can have a look on this and give the information to local authorities for the investigation. And also one of the things that came out of this exercise is that the National Infrastructure Agency from Colombia is going to build some guidelines for articulating in future projects the search for missing people. So I think this is a very good initiative for good practices that can be implemented in other projects, not only in Colombia, but also elsewhere. Especially, for example, in places that might not have armed conflicts now, but had before. So there might be still many missing people that needs to be found. Well, and the last thing is that I think these standards that we are developing and also the investigation that we are doing, the gathering of information that we are getting from all this that happened within the armed conflict with the FARC can be very useful for at least as a contextual element for the arbitration tribunals that might be established for any dispute between international investors and the Colombian state. And the last thing that I would like to say is that we, in IHL, there are like principles of the use of force in conduct of hostilities. So we have precaution, Professor Freya was talking about this, so we have distinction, proportionality, and precaution. So one of the things is that there is a war crime that says that you cannot launch an attack intentionally against the civilian population. So you will be not complying with distinction. That is the first rule. You need to distinguish if you are attacking another part of the conflict or if you are attacking a civilian population. So those principles of the use of force will be applicable, for example, in cases of if the investors are attacked within the armed conflict intentionally and they are not taking part in hostilities, that will be a war crime of attacking civilian population, for sure, I guess. I mean, most probably. And that will be the competence of the International Criminal Court to judge. So I think this is the way I try to bring together our knowledge. Well, thank you.
Thank you. Thank you, Justice Hidalgo. Very interesting, especially to realize that in a country such as ours, that is not only, I mean, as we already talked, 8 non-international conflicts, but also a transitional justice process going on as a consequence of the peace agreement relating one of those conflicts, well, one of the previous conflicts. There might be transitional justice obligations that need to be in place and that investors should take into account. And we are well over time, more than half an hour to where we plan, and I know that you have a commitment, myself as well. So I'm sorry not to elaborate in our discussion, but I think out of the presentations there are some questions that might be there for probably next year, or probably for you to research on. And in this, I have to do this closing, giving special thanks to Juan Sebastián Rivera and Isabela Blanco, who work with us, raising these questions, preparing the materials for our pre-panel discussion, and allow us to have this very interesting and coherent discussion on the topic, and also to Stefania and Maria Lucia, who help us put together this panel and to make sure that worked. Even at the end, we managed to hear very well Professor Mantilla, so I'm very happy for that. But some of the questions that arise are, for example, we discussed, and I think it was you, Jose Antonio, who raised the thing of responsibility for the damages caused by armed groups. But what about, of course, responsibility of the state, but what about the expectations of the investors when, for example, investors decide to come to a country such as Colombia that had 8 non-international armed conflicts? Are the legitimate expectations of those investors changed? And in that sense, Freya and Sebastián, the due diligence that applies to state conducts should also change in application to investors. And how can that interact? In the sense that, sure, maybe the state decided to take actions out of necessity, but then, and that affect the investors, but should the investors have that possibility into consideration when they decided to invest in a country like Colombia? And what that will create to the investment in countries that have ongoing and protracted armed violence. And also another thing that is interesting and that we should think about it is the political discussion. We know, and as coming from, and Freya coming from the international humanitarian law, international human rights world, we consider that determining, and especially in non-international armed conflicts, determining the elements of what a non-international armed conflict is objective and highly regulated. You have 2 essential elements: organization of the armed group and the intensity of the protracted violence that the state is suffering. And those are the 2 elements. But between those elements, there are subjective political considerations. Now, should investment arbitrations, and I know that we discussed this with Sebastián in the pre-panel extensively, should investment arbitration take into account those issues when it is highly repeated that they should not take into account internal political issues, but only address the issues related to the breach of the bilateral investment treaty, of the treaty that is giving them jurisdiction? That's also a topic that is very interesting to address. And finally, and Cesar was very clear in its presentation, showing how the history of the protection of investors show that although maybe we are addressing the connection between these 2 regimes of international law very recently, issues of conflict and investment have been in the world since a long time ago. This is not new. Actually, many agreements, friendship agreements, etc., came out of the need to protect states and states investors in times of armed conflict. So I think a very interesting question now is what comes next? And what comes next? And what's the role of investors in societies that are trying to make peace and to leave conflicts, and what's the role that they are going to play, especially when the investors have either the possibility or the need to contribute to that violence. And I think it was also you, Jose Antonio, who highlighted the fact that it has happened. And we have seen here in Colombia, remember that we have the massacre of the bananeras that was performed by United Fruit Company in complicity with the Colombian state, of course. But then 80 years later, we had before the State Department, Chiquita Brands International, United Fruit Company, 80 years later, recognizing that it has spent at least $1.7 million supporting paramilitary and guerrilla groups. And then the question there is, how could that affect transitional justice? And how could that affect transitional justice decisions? And are they responsible for doing it? They did it because they wanted to contribute to the violence in Colombia, or they did it because that was the only way they were going to be able to continue with their investment, activity in the country and the results of it. So these are many questions that at the end allow us to conclude that there is no true fragmentation relating to these topics. There are many points of connection between international humanitarian law and international investment law. And I think what we can conclude, it's a call for action that in a country such as ours, Colombia, or such as ours, Latin American countries that also suffer situations of protracted violence, there is a need for more research and more rigorous and more academic production related to the connection of investment law and international humanitarian law. With that, and although around 45 minutes late, but hoping that we can catch up and you can have a nice lunch before continuing to our third panel of the day. Once again, thank you very much for the World Arbitration Update, for our panelists, and hope to see you next year continuing the discussion on this topic. Freya, Sebastián, thank you very much for connecting, and Marcela and Cesar, thank you for coming. You coming from Ecuador, and you opening the space in your very, very tight agenda. So once again, thank you, Jose Antonio, our great host and panelist, for all your work and all the people behind it. And thank you for your participation also here in the panel. Thank you.